Hi, I'm Greg Dell, and I'm here with attorney Rachel Alters, and we're going to discuss an issue that has come up at least twice in the last week, which deals with two different situations. One is a person who, and it's kind of rare, who forgets that they bought a disability insurance policy many years ago, and then they find it, and they've been sick for many years, and they want to file a claim. And the other one is the person who's been sick but doesn't want to accept the fact that they're not going to be able to go back to work, so they wait many years often to not file the claim, because filing the claim to them would be an acceptance that they're actually unable to work, and emotionally a lot of people can't handle that. So, but that brings up potential problems when that happens, because these policies have requirements as to when a claim has to be filed, and if you don't comply with those, then a disability company could potentially say, we're not going to pay you.
Right.
But there are ways around that. And so how do you go about helping a person in this situation of filing a claim with what would be considered late notice?
This happens a lot, and it's happened a couple times recently with my clients. I'll give you one example. I have a Unum case that I filed. A client of mine who is an attorney, was an attorney, and got very sick and ended up getting a liver transplant. He, for probably 5 or 6 years, was bedridden. He was in and out of the hospital on multiple medications, and like you said, he was in denial and thought that he would get better and recover and be able to go back to practicing law, so he never filed. Calls me, and it's, several years down the road, and he's thinking there's no chance I'm going to get approved. Depends on the insurance company. Some insurance companies are willing to work with you when there's been very late notice, when there's a reasonable answer to that, meaning like they didn't have the ability to apply, they were too sick. The being in denial, I don't know that that's necessarily, if it's the only reason, that's going to get it past the proof of loss requirement. But this does happen often.
In a situation where you have a company like Unum, it's a contract, and as much as you hear horror stories about people, you still have situations where a company does try to do the right thing on a particular claim, because if you go by the contractual language, maybe sometimes they don't have to. But then again, was there a reasonable basis is what it comes down to not provide the notice of claim. Now, the particular claim that you just handled happened to be a claim in Florida. If that claim was in New York, the case law is very pro-insurance company, and it would be almost impossible to overcome a late notice claim in the state of New York, because the case law is so bad to say that if you don't put in timely claim, we're sorry.
Right.
We're just not going to pay you. And and this is a quasi what's called a statute of limitations, which is a big basis that a lot of insurance companies look to deny claims for. So what I would suggest to someone watching this video is that if you're in a situation with a late claim, absolutely call one of our lawyers right away. Let's discuss your strategy. Don't just call up the insurance company, because as soon as you call them, they're going to say, well, they're going to send you paperwork, and they're going to interview you right away. And you don't want to get caught telling them something that's going to hurt your claim right out of the box. Whereas if you have a plan going into it, like in this case, the client called you and then you took care of doing everything.
Right. Plus they record the calls. You can say something you can't take back. So that's something that you want to have a professional, an attorney like us, handle.
Okay. An important thing to note here, though, is that these were individual disability policies that you were working on, and not ERISA policies, which are employer-provided policies. I can tell you that you probably would not have had the success that you had if it was a group policy, because they're much more strict on those than on the individual disability policies. The other thing is that with a group policy, the employer is often paying the premiums, or once you leave that employment, you don't pay premiums anymore, so the policy dies.
Right.
But in this case, your client continued to pay premiums year after year after year on his policy. So worst case scenario in your situation, while the insurance company may not go back 5, 6, 7, or 8 years, maybe they only go back a year or a year and a half. And that's a strategy too, as to do you say the date of disability was 8 years ago, or do you say it was 1 year ago?
Right.
So that you don't get into a statute of limitations. So those are all issues that we'd have to discuss with any claimant that called us. So if you have a claim with Unum or any other long-term disability insurance company, whether you're applying or you need to appeal a denial, file a lawsuit, possibly a lump sum buyout, feel free to call any of our lawyers. We always offer a free consultation, and we look forward to the opportunity to speak with you.